Hello friends, today we are going to study about the Right to Information Act 2005, which is very important for the general public, for the government employees as well as for the students. It is specifically listed in the RS main syllabus. Now what we are going to cover in these slides is, first we will study about what is the right to information, then we will have a brief overview of the different sections of this act. After that we will cover each of the sections in detail. Then we will cover the issue of bringing the political parties within the ambit of RTI Act, and finally we will have a brief overview of the Right to Information Act in Rajasthan. Now we start with what is Right to Information. What is Right to Information Act? So RTI Act is an act to provide for setting up a practical regime for the right to information for citizens to secure access to information which is under the control of public authorities. What is public authorities is listed in the Right to Information Act as bodies which are substantially financed by the appropriate authority, that is the central or state government. So Right to Information Act is an act to provide for setting up the practical regime for right to information for citizens to secure access to information under the control of public authorities in order to promote transparency and accountability in the working of every public authority. The constitution of a central and state information commission for matters connected therewith or incidental thereto. So the RTI Act has the provision of a PIO, a public information officer at the first level, a first appellate authority at the second level, which is usually a senior officer within the department, and a second appellate authority, which is the Central or State Information Commission. Now, when was this RTI Act passed? It was passed on 15th of June 2005 and it came into force on 12th of October 2005. Now, 12th of October is regarded as the Information Day. It came into force in the whole of India except the state of J&K on 12th of October 2005. RTI is a legal right because the law was passed by Parliament. It has 6 chapters and 31 sections. We will first have a brief overview of the sections. Section 2 deals with definitions, which includes the definition of the public authority, what constitutes a public authority, definition of third party, definition of Central Information Commission and State Information Commission, what constitutes information under the Right to Information Act, what constitutes record under the Right to Information Act, and what constitutes right to information under the Right to Information Act. So this is covered by Section 2. Section 4 covers the obligations of public authorities. What are the public authorities obligated to do? So the public authorities, they need to make suo motu disclosures to the public in such a way that the public does not have to resort to the use of RTI Act. Also Section 4, 1 clause B, subclause B, it says that within 120 days of the enactment of the RTI Act, the public authorities need to disclose all important details like the particulars of their organization, the functions, the duties of the officials and employees, the budget allocated, the disbursements made to various agencies in the organization, the details of the beneficiaries of various schemes, etc. So all these disclosures need to be made by the public authorities. Also the public authorities need to provide details about how a citizen can apply for information from the government organization. We will study this in detail under Section 4. In Section 6, it deals with the request for obtaining information. So any citizen can file an RTI application under Section 6, subclause 1 of the Act. Section 5, it deals with the designation of the public information officers. So within 100 days of the enactment of RTI Act, every public authority needs to appoint a public information officer. Section 7 deals with the disposal of request under the RTI Act. Normally that request is disposed of within a 30-day period. If the information relates to the life or liberty of a person, then it needs to be disposed of within a period of 48 hours. And if the information relates to third party, it needs to be disposed of within a period of 40 days. Then Section 8. Section 8 covers the various exemptions from disclosure of information under the RTI Act. Then Section 9. Section 9 also deals with the ground for rejection of application for information, and the ground for rejection is copyright infringement. So if the information sought, it infringes on the copyright of an individual other than the state, then it can be rejected. In Section 12, Section 12 deals with the formation of Central Information Commission. Section 12, subclause 1 deals with the formation of Central Information Commission. Section 12, subclause 3 deals with the Chief Information Commissioner and the Information Commissioners at the central level. Chief Information Commissioner and the other Information Commissioners at the central level. And Section 15. Section 15 deals with the State Information Commission. Section 15 subclause 1 deals with the State Information Commission. Section 15 subclause 3 deals with the Chief Information Commissioner and the other Information Commissioners at the state level. The State Chief Information Commissioner and the other Information Commissioners at the state level. Now, the Central Information Commissioner, the Chief Central Information Commissioner and the other Information Commissioners. There is a provision that there can be one Chief Central Information Commissioner and not more than 10 other Information Commissioners at the central level, and the same similar provision at the state level also. One Chief Information Commissioner and not more than 10 Information Commissioners at the state level. Now, Section 12 deals with Central Information Commission. Section 13 deals with the tenure and service conditions of the Central Information Commissioner, which at present is regulated by the central government. It was done by the amendment to RTI Act that now the central government will regulate the tenure and service conditions, and the tenure and service conditions of the Central Information Commissioner is going to be as determined by the central government. Then Section 14 deals with the removal of the Central Information Commissioners. Section 15 we already covered, deals with the State Information Commission. Section 16 deals with tenure and service conditions of State Information Commissioners, which after the 2019 amendment will be as regulated by the central government. Then Section 17 deals with the removal of State Information Commissioners. Section 18 deals with powers and functions of Information Commissioners. Section 19 deals with the appellate procedure under the RTI Act. First appeal is to a senior officer within the department, and the second appeal is to the Central Information Commission or the State Information Commission, depending on whether the government organization is at the state level or the central level. Then Section 20 deals with penalties under the Act. The penalty for not providing incorrect information, or not receiving the application without reasonable cause, it is ₹250 per day till the information is provided or till the application is received, subject to a maximum of ₹25,000. And Section 21 to 31, it deals with the miscellaneous provisions. Section 24 deals with the provisions with regard to the organizations that are exempted under the RTI Act. Section 24 deals with provisions with regard to organizations that are exempted under RTI Act. And second schedule covers the name of these organizations, second schedule of RTI Act. Now this was a brief overview of the various sections of RTI Act. Now we come to the various sections in detail. Before studying the sections in detail, we will first study a case which is called the Zee Telefilms case, Zee Telefilms Limited versus Union of India. In this case, the court said that the right to speech mentioned in Article 19, it is incomplete without the right to know. And also the right to live with dignity, as mentioned in Article 21, is incomplete without the right to know the process of the working of government. So, the right to information or the right to know is very important, because the right to speech under Article 19 and the right to live with dignity under Article 21, right to live with dignity, both these rights, they are incomplete without the right to know or the right to information. Now, in this Zee Telefilms case, for the first time, the issue of whether the BCCI, it should be treated as a public authority or not, this issue was first brought before the court in the Zee Telefilms case. Now we will first study about this issue of bringing BCCI under the RTI Act. Now BCCI is the regulatory body for cricket in India. It has virtually monopolistic powers with respect to regulating cricket in India. And the Indian cricket team, when it is playing at international level, it is said to represent the BCCI. The BCCI is actually a private body. So when the Indian cricket team, it plays internationally, it is said to represent the BCCI, but Indian cricket team is actually representing the people of India also. And BCCI, due to its monopolistic role, its decisions are affecting the people of India also. Now the Supreme Court judgment of 2005, Supreme Court in the year 2005, Supreme Court had ruled that BCCI could not be termed as an instrumentality of state. BCCI could not be termed as an instrumentality of the state under Article 21. So BCCI cannot be termed as an instrumentality of state under Article 21. This was ruled by the Supreme Court in 2005. Now Article 21, we know it covers the definition of state. So in 2005, Supreme Court had in a said that BCCI will not be covered under public authority. However, subsequent developments have increasingly implied the public character of the BCCI's functioning. Now the BCCI's monopolistic activities, they directly or indirectly affect the fundamental rights of the stakeholders. And the stakeholders, they include the citizens, players, and other functionaries. And private citizens, they should be able to move the Supreme Court, the highest court, against the BCCI for violation of fundamental rights. Now the Law Commission. The Law Commission in 2018, the Law Commission, it said that the BCCI should be declared a public body. Law Commission said that BCCI, it should be declared as a public body. Now the reasons that the Law Commission gave were that the Indian Cricket Council recognizes the BCCI as an official body representing India. And BCCI exercises state-like powers in the regulation of cricket. So BCCI exercises state-like powers. State-like powers in regulation of cricket. So BCCI should come under the definition of state, and it should be brought under the RTI Act. Also, the Law Commission said that the BCCI, it virtually acts as a national sports federation. And the national sports federations in India, they are under the control of Ministry of Youth Affairs and Sports. And the Law Commission said that Ministry should mention the BCCI in the list of national sports federation. And as soon as the Ministry lists the BCCI as a part of the list of the national sports federations, then BCCI will automatically come under the RTI Act. So in brief, we can say that Supreme Court in its 2005 order, it said that BCCI cannot be covered as an instrumental, cannot be termed as an instrumentality of the state under Article 21. So in a way, Supreme Court said that it is not a public authority, but the subsequent developments, they have increasingly implied the public character of the BCCI's functioning, because the BCCI is regulating cricket in India and has virtually monopolistic powers, and BCCI exercises state-like powers in the regulation of cricket in India. Hence, it should be covered under the definition of public authority. This was also recommended by the Law Commission in 2018. Now we come to the different sections of the RTI Act. What are the different sections of the RTI Act? We will cover them in detail. So first section, Section 2. Before Section 2, the Section 1 of the RTI Act, Section 1 of the RTI Act deals with the general provisions like commencement of the Act, etc. So Section 2 is an important section, and the subclause 1, the subclause A of the Section 2, it deals with the definition of appropriate authority. So appropriate authority means in relation to public authority which is owned, controlled or substantially financed by funds provided directly or indirectly by the central government or UT administration. In that case, appropriate authority will be central government, and if it is financed, if it is owned, controlled and substantially financed by funds provided by state government, in that case, the appropriate authority will be state government. Now subclause B. Subclause B says Central Information Commission means the Central Information Commission constituted under the subsection 1 of Section 12. You already studied that under the Section 12 subclause 1, it covers the Central Information Commission, and the Section 12 subclause 3 covers the Chief Information Commissioner and the other information commissioners at the central level. And these other information commissioners are going to be not more than 10. And there is going to be one Chief Information Commissioner. Then subclause C, it says Central PIO means the Central PIO designated under subsection 1 of the Section 5. And Central Assistant PIO designated under subsection 2 of the Section 5. Now, what is a Central Assistant PIO? Central assistant PIO is appointed usually at the subdivision level, that is at the block level, in order to ease access of the people for right to information. How? Because in big districts, the people are sometimes unable to access the district level because there is a lot of travel time, lot of expenditure involved. So for ease of access at the subdivision level, there is an assistant PIO provided. Now the person can file an application before this assistant PIO, and the assistant PIO will transfer the information to the PIO within a period of 5 days. So in this case, in normal case, the information needs to be disposed of, needs to be provided within the 30-day period. But in case the RTI application is filed before the assistant PIO, the information will be provided in a period of 35 days. 5 days extra for response will be provided. Now subsection D. We already covered it. It covers the Chief Information Commissioner and the Information Commissioners at the central level. Subclause E. It deals with competent authority. What is competent authority? Competent authority will be the Speaker in case of the Lok Sabha or Legislative Assembly of a state or UT having such assembly. The competent authority will be the Chairman in case of Rajya Sabha or Legislative Council of the state. Competent authority will be Chief Justice of India in case of Supreme Court. Competent authority will be Chief Justice in case of High Court. And the competent authority will be President or Governor, as the case may be in case of other authority established or constituted by or under the Constitution. And the competent authority will be the administrator appointed under Article 239 of Constitution in case of Union Territory. Now we will briefly summarize this section. What is competent authority? So in case of Lok Sabha or the Legislative Assembly of State, or of a union territory having such assembly such as Delhi or Puducherry, the competent authority is going to be Speaker. In case of Rajya Sabha or Legislative Council of the state, the competent authority is going to be Chairman. In case of Supreme Court, competent authority will be Chief Justice of India. In case of High Court, competent authority will be Chief Justice of High Court. In case of any other authority established or constituted under the Constitution, the competent authority will be President in case the body is constituted at the central level, and Governor in case the body is constituted at the state level. And the competent authority will be the administrator appointed under Article 239 of the Constitution in case of Union Territory. Now administrator is appointed by the President of India, and also the Governor of a neighboring state can be appointed as the administrator of a Union Territory. So the competent authority will be the administrator appointed under Article 239 of Constitution in case of Union Territory. Now we come to the next provision, next subclause, very important. What is information under the RTI Act? Information includes any material in any form, including the following. Now all these are covered under information. For ease of memorization, I have clubbed them into separate groups. This is known as the chunking method. So clubbing them into different groups on the basis of certain similarities helps us memorize things faster. So we go to the first group. The first group is memos, press releases, circulars and orders. Now we know that memo in Hindi is known as Gyapan. Press release in Hindi is known as Vigyapti. Press release in Hindi is known as Vigyapti. Circular in Hindi is known as Paripatra. Order in Hindi is known as Karyalaya Adesh. Now many viewers of this video will be RS aspirants because RTI Act is included in the RS main syllabus. So we know that in our paper 4 of the RS main syllabus, which includes Hindi, and we have all these in our syllabus, that is Gyapan, Vigyapti, Paripatra and Karyalaya Adesh are included in our syllabus for Hindi under paper 4. So we can use this to memorize these names: memos, press releases, circulars and orders. Gyapan, Vigyapti, Paripatra and Karyalaya Adesh. Then the next group. It includes documents, papers, data material held in any electronic form and reports. So these have certain similarity and hence they can be clubbed together for memorizing documents, papers, data material held in electronic form and reports. Now we move to the next group. Now samples and models, they can be clubbed together. Also, we can include record in this group for memorization. So record, samples and models. Then email, opinion, advice. Now advice, we can remember it through a pictorial representation like this. Now in comic books, it is often seen that when one person is talking to another person, suppose this person is talking. So there is a sign, a symbol made like this, and whatever this person is saying, it is shown in the form of text. So this person giving advice, one person giving advice to another person. So we can remember it using this pictorial symbol. Then about opinion. Opinion is usually, opinion is often not said aloud. Many times the opinion is not said aloud. So opinion can be represented with the help of a dotted line. Using this symbol, you can memorize it in this way. So this is for ease of memorization. So logbooks and contracts are also included under the definition of information. Also information relating to any private body, which may be accessed by any public authority under any other law for the time being in force. So information relating to any private body which may be accessed by the public authority under any other law, it is also included under the definition of information under RTI Act. Then we move to the next subsection, that is subsection 2H, which deals with what is public authority. So what is public authority under RTI Act? So public authority means any authority or body or institution of self-government established or constituted by or under the Constitution, by or under a law made by Parliament, by any other law made by the state legislature, by notification issued or order made by appropriate government, by notification issued or order made by appropriate government, and includes any body owned, controlled and substantially financed. So body owned, controlled and substantially financed by appropriate government, and also includes NGOs that are substantially financed directly or indirectly by appropriate government. So these are included in the definition of public authority. Again, I summarize it. Public authority means any authority or body or institution of self-government established or constituted under the Constitution, under law made by Parliament, under law made by state legislature, or by any notification issued or order made by appropriate government, and which includes any body owned, controlled or substantially financed by the appropriate government. Also includes any NGO that is substantially financed directly or indirectly by the appropriate government. Now we move to the next section, that is section 2I of the RTI Act. It covers what is record. So what is record under RTI Act? Record includes any document, any manuscript, that is handwritten document, any file. It also includes any microfilm, any microfiche or a facsimile copy of a document. Now we will see briefly what is microfilm, what is microfiche and what is facsimile copy. So microfilm, it is a 35 mm film on which printed materials are photographed. So it is a 35 mm film on which printed materials like newspapers, catalogue or other documents, they are photographed at a greatly reduced size, at a very small size for ease of storage. So they are photographed at a very greatly reduced size for ease of storage. And how are they read? So the digital lens on the microfilm reader, there is a microfilm reader and on that there is a digital lens, and this digital lens, it enlarges the image of the material, allowing you to read the contents. So this is what is microfilm. Now microfiche, it is very similar to a microfilm. Microfiche is a card made of transparent film. So it is a card made of transparent film used to store printed information like newspaper, catalogue, other documents in miniaturized form. And to read this card, one places this card under the reader. One will place this card under the reader. Suppose this is the reader. Places it under the lens of a microfiche reader. So this is a microfiche reader and this has got a lens in it. Under this lens, the card will be placed. The microfiche card will be placed, and this lens allows you to read the content. There is a machine and it has got this reader machine has got a lens, and this lens allows you to read the content on the microfiche card. So it is a thin film on which printed material is stored at a greatly reduced size, and it is read with the help of a lens. Now what is facsimile copy? Facsimile copy means an identical copy, an exact or identical copy of a document. Now, record also includes any reproduction of image or images embodied in such microfilm, whether enlarged or not. So any image or images that are embodied in such microfilm, any reproduction of these image or images, whether enlarged or not, is included in the definition of record. Any material produced by a computer or by any other device is also included in the definition of a record. Now we move to section 2J of the RTI Act. Section 2J is very important. It deals with what is right to information. So right to information accessible under this act, which is held by or under the control of any public authority. So right to information accessible under this RTI Act, which is held by or under the control of public authority, and includes the right to inspection of works, documents and records. So it includes the right to inspection of the works, documents and records. So I have shown this inspection with the help of a magnifying glass just to symbolize inspection. So inspection of works, documents and records is included under right to information. Then taking notes, extracts or certified copies of documents or records also included under right to information. A person can ask for notes, extracts or certified copies of documents and records. Then taking extract of certified samples of material also included in RTI Act. Taking information in the form of diskettes, floppies, tapes, video cassettes or in any other electronic mode, or through printouts where such information is stored in a computer or any other device. So taking information in electronic form or in printed form also included under the right to information. Now we move to the next section, that is the section 2 subclause K. So section 2 subclause K says State Information Commission means the State Information Commission constituted under subsection 1 of section 15. Now section 15 subclause 1, it covers the State Information Commission, and subclause 3 of section 15 covers the Chief Information Commissioner and the Information Commissioners at the state level. And we know that there is going to be one Chief Information Commissioner and not more than 10 Information Commissioners. Now we come to another important section, that is section 4 of the RTI Act. Section 4 of the RTI Act, it deals with the obligations of public authority. So what are the obligations of the public authority? So section 4, subclause 1, it says, subclause 1 says that every public authority shall maintain all its records duly catalogued and indexed in a manner and form which facilitates right to information under this Act. So public authority will maintain all its records duly catalogued and indexed in a manner and form which facilitates the right to information under this Act. Then section 4 subclause 2, it says that it shall be the constant endeavor of the public authority to provide as much information, suo motu, that is on its own, to the public at regular intervals through various means of information, so that the public have minimum resort to the use of RTI Act to obtain information. So the public authority should give information suo motu or on its own to the public at regular intervals, so that the public have minimum resort to the use of RTI Act. Public don't even have to resort to RTI Act if the information is disclosed by the public authority on its own. Now there is section 4 subclause, section 4(1) subclause B. This says that within 120 days of the enactment of RTI Act, within 120 days, every public authority needs to publish the details relating to the organization on its website. Now what are these details that the public authority needs to publish? So these include, first is the particulars of the organization. First is the particulars of the organization. including the functions, and duties of the various employees in the organization. And second, it needs to disclose the powers and duties, the powers and duties of its officers and employees. It also needs to disclose the norms set by the organization for discharging its functions need to be disclosed. Also, the procedure to be followed in decision making process, and the channels of supervision and accountability need to be disclosed. Then the rules and regulations of the organization, the instructions, manuals, records held by the organization, they need to be disclosed. Also, the categories of documents held by the organization need to be disclosed. Also, the statement of the boards, councils, committees, councils, etc. That the statements of boards, councils, committees that consist of 2 or more persons. They are constituted for the purpose of advising the organization. So, if the organization has constituted certain boards or committees for the purpose of advising the organization, then the details relating to these boards and committees, they need to be published. And also whether the meetings of these boards and committees, they are open to the public or not. This needs to be disclosed. Also, if the boards or committees are conducting any meetings, then the minutes of the meetings need to be disclosed. Also, the directory of the different names directory consisting of the names, the contact numbers of the officials need to be disclosed. Also, details regarding the monthly remuneration that is received by the employees and officials needs to be disclosed. The details regarding the system of compensation as provided in the regulation of the organization need to be disclosed. Also, the details regarding the budget allocation to the organization and how the disbursements relating to budget they are made to different agencies of the organization, these details need to be disclosed. What is the proposed expenditure by the organization? These details need to be disclosed. Also, the manner of execution of subsidy programs by the organization need to be disclosed. Also, details of the beneficiaries of various schemes need to be disclosed. The beneficiaries of different programs of the organization need to be disclosed. Particulars of recipients of the concessions and permits given by the organization need to be disclosed. Recipients of the authorizations given by organization, particulars of those recipients need to be disclosed. And also the particulars of the facilities available to the general public for obtaining information from the organization. These also need to be disclosed. The names and designation, the names of the PIO and the designation of the PIO, the public information officer in the organization need to be disclosed. Also, the organization needs to publish details of the facts that it took into consideration before framing its policies. And the organization needs to give reasons for all the administrative and quasi-judicial decisions that it took and that affected the public at large. Now, all this information needs to be provided in the local language and in a form that is easily accessible to the public, and also keeping in mind the cost effectiveness. So this was in brief about the section 4 of the RTI Act. Now we move on to section 5 of the RTI Act. Section 5 says, it talks about the appointment of public information officers. So section 5, it talks about the appointment of public information officers. So every public authority will designate a public information officer, that is the central or state public information officer, within 100 days. Within 100 days of the enactment of RTI Act, every public authority needs to designate the public information officer. And at the subdivision or sub-district level, assistant PIO may be appointed to receive the application and appeals and then to forward it to the PIO. And if an assistant PIO is appointed, then 5 extra days will be given for response. So earlier if the information was provided within 30 days, now it is to be provided within 35 days because 5 days are taken by the assistant PIO to transfer the application to PIO. So whatever the prescribed period is, if it is 30 days, then 5 days are added and the prescribed period becomes 35 days. So whatever is the prescribed period, it is 30 days in case of normal information, it is 48 hours in case of information relating to life and liberty, and it is 40 days in case of third party. So 5 days will be added to the prescribed period in case the information, the application, the RTA application is received by the assistant PIOs. 5 extra days for response in case the application is received by the assistant PIO. Then PIO is to deal with the request for information, and PIO will also render reasonable assistance to the applicant. Will provide all possible assistance to the applicant for filing the application and for receiving the application. Now the PIO may seek assistance. The PIO may seek assistance of any other officer also. The PIO may seek assistance of any other officer for providing information, and such other officer whose assistance is sought by the PIO is bound to render assistance to the PIO, and in case that other officer does not provide the information, does not give assistance to the PIO, then that officer will be treated as PIO for the contravention of provisions of RTI Act. So penal action can be taken against that other officer in case that other officer does not provide assistance that is asked by the PIO. Now section 6 of the Act. Section 6 deals with the request for obtaining information. So any citizen can file an RTI application under section 6 clause 1. And the application can be filed in writing or in electronic means in English or Hindi or in the official language of the area where the application is filed, where the RTI application is filed, and by giving such fee as may be prescribed, it is normally 10 rupees. And if the person is from BPL category, then no fees is charged. And no reason is required for filing the RTI application. The applicant needs to disclose no details except those details that are necessary for contacting him, which can be like phone numbers or address, etc. Then if the public authority receives information held by another public authority. So we will understand this with the help of an example. Suppose the PIO is related to the Public Works Department. The PIO is from the Public Works Department and the applicant, the RTI applicant has asked for information which can be found only with the Water Resources Department. So if the information relates to Water Resources Department but the applicant due to lack of knowledge has filed an RTI application with the PWD department. Now the PIO of the PWD department will transfer the request, will transfer the RTI application request to the PIO of the Water Resources Department within a period of 5 days. And will also inform the applicant immediately about such transfer. So request for obtaining information, request has to be, we have already studied the first point, no reason is required, we have covered it. If the public authority receives information held by another public authority, then the concerned PIO has to transfer the RTI application to the other public authority within 5-day period and inform the applicant immediately about such transfer. Now section 7 of the RTI Act. Section 7 deals with the disposal of request. So section 7 says that the PIO has to either provide the information within 30 days or reject the application for information for any of the reasons specified in section 8 or 9 of the RTI Act. Section 8 provides certain exceptions for disclosing of information, and section 9 also says that if the information relates to copyright infringement of any individual other than state, then the information is not to be provided. And if the information relates to life and liberty of a person, then the PIO has to respond to the application within 48 hours. Either give the information or reject the appeal within a 2-day period. Then if the central or state PIO doesn't provide information within prescribed time, if the information is not provided within prescribed time, then the PIO shall have deemed to have refused the request. So if the PIO doesn't provide information within the prescribed time period, then the PIO shall be deemed to have refused the request. It means the PIO has refused the request. This will be deemed. If he or she does not provide information within the prescribed period. Now, if the fee is to be deposited, then the PIO, now in some cases, fee requires to be deposited. So we'll understand this with the help of an example. Suppose the applicant has asked for information which needs to be provided. Suppose 200 pages of information is asked by the applicant, and photocopy is to be done for providing this information. So 200 pages need to be photocopied in order to provide this information to the applicant, and the cost of photocopying is ₹1 per page. So in this case, the PIO will write a letter to the applicant saying that you need to deposit ₹200. You need to deposit ₹200, and the PIO will also list that since the cost of photocopying is ₹1 per page, so and there are total of 200 pages to be photocopied, so the cost is 200. And these are the calculations that are made to arrive at that amount. So this is about when the fees is to be deposited for giving the information. So if the fee is to be deposited, then the central or state PIO will send intimation to the person giving details of further fee and the cost of providing information and the calculations made to arrive at that amount. Now suppose the RTA application, it was filed on the 6th of September. The PIO received the application on 6th of September, and now the fees needs to be deposited. So PIO will write to the applicant saying please deposit 200 rupees. Suppose on 10th of September the PIO writes a letter to the applicant asking the applicant to deposit ₹200, and the applicant deposits this ₹200 on 16th of September. Now normally 30 days would expire on 6th of October, but since the applicant has taken 6 days to respond to the letter asking for fees, so these 6 days are not to be counted towards the 30-day period. So now the PIO will be giving the information on the 12th of October, can give the information up to 12th of October. So total time available will be now 36 days, because these 6 days will not be included towards the counting of 30 days. Now the same is listed in this article, in this section. If the fee is to be deposited, then the PIO is to send an intimation to the person giving details of further fee, the cost of providing the information, the calculations made to arrive at that amount, and the period intervening between the dispatch of the said intimation. That is, on 10th September the intimation was dispatched. The period intervening between the dispatch of the said intimation and the fee payment, that is on 16th September. The period is 6 days. So this 6-day period shall be excluded for calculating the 30 days. Now the subsection 4 of section 7 says if the applicant is disabled, then the PIO will render reasonable assistance to the applicant. Subclause 5 of the section 7, it says that if the applicant is from BPL category, no fees is to be paid. No fees charged from the applicant. No fees means that 10 rupees will be exempted. Also, no other fees will be charged. Then subclause 6 of the section 7 says information will be given free of charge if the public authority doesn't comply with the time limit. So if the public authority doesn't comply with the time limit, the public authority does not give the information within the prescribed time limit, which is normally 30 days. It is 2 days in case of information relating to life and liberty, it is 48 hours, and it is 40 days in case of third party. So if the public authority doesn't comply with the time limit, doesn't give the information within the prescribed time limit, then the information needs to be provided free of charge. Now subclause 7 of section 7, it says before taking any decision, the PIO has to consider the representation made by the third party under section 11. So this is with regard to third party information. So we will just cover this aspect of third party information with the help of an example. Now suppose an applicant applicant A has filed an RTI application to the PIO. And now this information, it relates to third party. That is any other person other than the applicant. It relates to the third party. Now the PIO will, within a period of 5 days, the PIO will write a letter to the third party, will give notice to the third party, asking the third party, please reply, please give in writing or orally your decision whether we should disclose the information or we should not disclose the information. Please either give your consent or you refuse your consent within a period of 10 days. So the third party will be given 10-day period to make a representation to the PIO, telling the PIO whether the third party wants the information to be disclosed or whether it does not want the information to be disclosed. And this representation made by the third party, it will be considered by the PIO. It will be considered by the PIO when making a decision with respect to disclosure of the information. Now, suppose the third party does not consent to the disclosure of information. In that case, the PIO, even in that case, the PIO can still disclose the information if the PIO thinks that the public interest in disclosure of information outweighs any harm to protected interest. If the public interest in the disclosure outweighs any harm to protected interest, then the PIO can still take a decision to disclose the third party information. And the PIO will give notice of his or her decision to the third party. So the subclause 7 of section 7 that we were just reading, what does it say? It says that before taking decision, the central or state PIO has to consider the representation made by the third party under section 11, which is third party has to give a representation within 10 days. And the PIO needs to consider this representation while making a decision. And section 11 covers the information related to third party. We are going to study about section 11 in the subsequent slides. Now subclause 8 of the section 7. Subclause 8 says that if the RTI application request is rejected under subsection 1, if the RTI application request is rejected, then the PIO will inform the applicant about the reasons of rejection, about the period in which the appeal can be preferred. So appeal can be preferred in a 30-day period. This is to be informed by the PIO to the applicant. And also the particulars of appellate authority. The PIO will inform the applicant about who is the appellate authority within the organization. It is usually the senior officer within the organization. The particulars of the appellate authority, how to contact the appellate authority, the period in which appeal can be made, all these details will be disclosed by the PIO to the applicant. Also the PIO will give reasons for rejection. Now information, this is subclause 9 of the section 7. Information to be ordinarily provided in the form in which it is sought. Information is usually provided in the form in which it is sought. Suppose the applicant has asked for information in printed form, then it is to be given in printed form. If applicant has asked for information in electronic form, it needs to be given in electronic form. So information to be ordinarily provided in the form in which it is sought, unless it would disproportionately divert the resources of public authority. So in case the giving of information, the providing of information, it leads to disproportionately diverting the resources of public authority, then it can be given in the form other than the form that is sought by the applicant. Also, if the disclosure of information in the form that is sought by the applicant, it is detrimental to the safety or preservation of the record in question. Suppose applicant has asked for a record in printed form, and if the record is given in printed form, it can lead to damage to the record itself. And in that case, information can be provided in a form other than the form that is sought by the applicant. Now we come to section 11 that deals with third party information. We have already covered this section. We will again revise it. Section 11 leads to third party information. Now what is third party? Third party is a person other than the citizen making the request for information and includes a public authority. Now suppose a person A is the RTI applicant and he has filed an application before the PIO. Now third party will include any person other than A. So it is any person other than A, and the third party includes anyone other than the citizen making the request. other than the citizen making the request, and third party also includes the public authority. So third party can include both an individual other than citizen making the request, and it can also include a public authority. Now the procedure for third party information, how it is to be disposed of. We have already studied this. We will again revise it in brief. Now suppose a person has filed an RTA application before a PIO, and this is the RTA applicant. And now this information, it relates to third party. So PIO will, within 5 days, PIO will write a letter to the third party asking the third party, please give your response about whether you consent to disclosure of information or you do not consent to disclosure of information. Now third party will, within a period of 10 days, third party will make a representation before the PIO, and third party will give its decision whether it consents to disclosure of information or whether it does not consent to disclosure of information. And PIO will consider this decision given by third party, this response given by third party, by making a decision whether to disclose the information or not. Now suppose the third party consents to disclosure of information, then PIO will disclose the information. But suppose the third party does not consent to disclosure, then either the PIO can agree to it, or the PIO can even still take a decision to disclose the information. If the PIO thinks that the public interest in the proposed disclosure of third party information, it outweighs any harm to protected interest. So if the PIO thinks that public interest in the disclosure of this third party information outweighs any harm to protected interest, in that case the PIO can still take a decision to disclose the third party information even if the third party has not consented to the disclosure, and the PIO will give in writing the notice about his decision to the third party. Now third party, suppose the PIO takes a decision to disclose the information against the response given by third party. Third party says don't disclose the information, and PIO still decides to disclose the information because the public interest, PIO thinks that public interest is outweighing harm to protected interest. In that case, third party can file an appeal against the PIO to the first appellate authority within a period of 30 days from the order of the PIO, from the 30 days from the decision taken by the PIO. So appeal can be made under section 19. So this was about section 11 of the RTI Act. Now we come to a very important section, that is section 8 of the RTI Act. Section 8 covers the exceptions that are provided from disclosure of information under RTI Act. So what are the exceptions? The exceptions are under subclause A. Information which can prejudiciously affect the sovereignty and integrity of the country, the security and strategic and scientific or economic interests of the state, the relations with foreign states, and which may lead to incitement of offense, is forbidden from disclosure under the subclause A of the section 8. Then information which is expressly forbidden to be published by any court of law, the disclosure of which may constitute contempt of court. So if it is forbidden by a court of law or disclosure constitutes contempt of court, then it cannot be disclosed under section 8 of the RTI Act. Now, if disclosure of information can cause breach of privilege of parliament or state legislature, then it cannot be disclosed. Information including trade secrets. So information including trade secrets or commercial interests or intellectual property, the disclosure of which would harm the competitive position of a third party, unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. So third, information including trade secrets, intellectual property, commercial interests, the disclosure of which would harm the competitive position of the third party, it cannot be disclosed unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. Then information received in confidence from a foreign government. So information received in trust from foreign government cannot be disclosed. Cabinet papers. So deliberations of the cabinet. Cabinet papers including records of deliberations of council of ministers, secretaries and other officers. It cannot be disclosed. Then personal information, it cannot be disclosed unless it serves the larger public interest. So we just studied that cabinet papers, including records of deliberations of council ministers, secretaries, officers, cannot be disclosed. Also, the disclosure can be only made after the suppose cabinet has taken a decision, and in case the PIO decides that disclosure is to be made, the disclosure can be made only after the decision is complete. Only after the decision has been taken or the matter is complete, in case the disclosure is to be made. And also, if the cabinet is deliberating on a matter which relates to any of these points, that is the exceptions provided under RTI Act. If cabinet is deliberating on any of these matter concerning sovereignty of the country, or matter which relates to information received in trust from foreign governments, all these things, if cabinet is deliberating on these matters, then they cannot be disclosed under the RTI Act. Now, personal information cannot be disclosed unless it serves the larger public interest. Also, Section 8.2, Section 8 subclause 2, it says that it talks about the information forbidden to be disclosed under Official Secrets Act. So, Official Secrets Act, it says that certain information cannot be disclosed in public domain. But now, if the public interest outweighs any harm to protected interests, then even information that is forbidden from disclosure under Official Secrets Act, it can be disclosed under the RTI Act. So RTI Act can override this Official Secrets Act if the public interest outweighs harm to any protected interest. Also, information which cannot be denied to the parliament or state legislature, information which cannot be denied to the parliament or to the state legislature, it cannot be denied to any person also. Now we have covered the exceptions under Section 8. In exam, we often have a question asking write the exceptions that are provided under Section 8 of RTI Act. Now we will just see a technique for memorizing all these exceptions. So in this technique, we have used the chunking method. Chunking method, as we know, it is clubbing similar things together. So first group we have made is court and police. So all these exceptions, they are in some way related to court and police. Now, information forbidden by a court of law from disclosure, it cannot be disclosed under RTI Act under the subclause B of Section 8. Then offense, it is somehow related to police and court. So information which leads to incitement of an offense, it cannot be disclosed under subsection A of Section 8 of RTI Act. Then offenders, again related to court and police. So under Section H under the subsection H of Section 8, information which hampers investigation of and prosecution of offenders. Information which hampers the investigation and prosecution of offenders, it cannot be disclosed under RTI Act under subsection H. So we can also remember it using H and hampers, both have H. So under subsection H, information which hampers investigation into prosecution of offenders, it cannot be disclosed under RTI Act. Then information which endangers the life of a person, or information which identifies the source of information or assistance, which identifies the source of information or assistance given in confidence, that is given in confidence for law enforcement or security purposes, for law enforcement or security purpose. So this information cannot be disclosed under subsection G of the Section 8 of RTI Act. So as we can see, law enforcement related to police. So in this way we can remember it using the chunking method. Now we go to the next group for memorizing. Next group relates to cabinet and parliament. So these two are related to cabinet and parliament. So cabinet papers under subsection I of Section 8, cabinet papers, records of deliberations of council of ministers, secretaries and officers, exempted from disclosure under subsection I of Section 8 of RTI. Then Information that is causing breach of privilege of Parliament or State Legislature. It is exempted from disclosure under subsection C of the section 8 of RTI Act. Subsection J, we can remember this separately. It deals with information that causes invasion of privacy. Invasion of privacy of individual. It is exempted from disclosure under RTI Act. Then we move on to the next group. Information which adversely affects, prejudiciously affects the sovereignty, integrity, security, strategic, scientific and economic interests of the state, or which adversely affects the relations with foreign states. It is forbidden from disclosure under subsection A of section 8 of RTI Act. Also, under the same subsection A, information which leads to incitement of offense, it is forbidden from disclosure under RTI Act. Then information that is received in trust from a foreign government, that is received from a foreign government in trust, it is forbidden from disclosure under subsection F of the section 8 of RTI Act. So we can also remember it using F and foreign. Foreign starts with F. So under subsection F, information received from foreign government in trust is forbidden from disclosure under RTI Act. Then when we talk about trust, then the next word which comes to our mind is trustworthiness. So we can move on to the next point. So next point says that under subsection E of the RTI Act, information available to a person due to his trustworthiness, that is available to a person in his fiduciary capacity, that is forbidden to be disclosed under RTI Act. Now we have just studied all the exceptions provided under section 8. Now information can be disclosed even if it relates to all these exceptions if the public interest, it outweighs any harm to the protected interest. So if the public interest, it outweighs any harm to the protected interest, then the information can be disclosed. Now there is another provision which says that any information relating to any occurrence, event or matter which had taken place, occurred or happened 20 years before the date on which the request is made, under section 6 shall be provided to any person making the request under that section. So if an event has occurred, if an event has occurred 20 years prior to the filing of RTI application, then PIO may consider giving the response, giving the information. It is subject to the provisions of clauses A, C and I of subsection 1. So it is subject to the restrictions given in subclauses A, C and I of subsection 1. Provided that where any question arises as to the date on which the said period of 20 years has to be computed, the decision of the central government shall be final, subject to usual appeals provided under the Act. So how to compute these 20 years? If any question arises as to the date from which the 20-year period is to be computed, the decision of the central government will be final. So in brief, if any information is asked relating to an event which occurred 20 years prior to the filing of the RTI application, then the PIO may consider providing that information to the applicant, and how these 20 years are to be calculated, that is to be decided by the central government. From which date the 20-year period is to be calculated is to be decided by the central government, and this is subject to provisions of subclause A, C and I of the subsection 1 of section 8. Now we move on to the next very important section, that is section 19 of the RTI Act. It deals with appellate procedure under the RTI Act. So we know that the first level is the PIO, then there is the first appellate authority, which is usually the senior officer within the department, and then there is the second appellate authority, which is usually the Central Information Commission or the State Information Commission. So this is the mechanism, the structure under RTI. Also at the subdivision level, an assistant PIO may be there, and this is provided. The assistant PIO is to assist the PIO, and if the RTI application is received by the assistant PIO, then 5 additional days will be given for responding to the RTI application. 5 days extra. So we are going to study about the appellate mechanism. The first point says appeal against the PIO to senior officer is to be made within 30 days of the receipt of decision. 30 days of the receipt of decision of the PIO or expiry of the prescribed period. So if the PIO has given a decision within 30 days, appeal can be made. Suppose the PIO has not taken any action, then when the 30-day period, the prescribed time period expires, then after that the appeal can be filed. Now the appeal can be admitted by the first appellate authority, even after 30 days if the first appellate authority is satisfied that applicant was prevented by sufficient cause from filing the appeal in time. So if the first appellate authority is satisfied that the applicant was prevented by sufficient cause from filing the appeal in time, some genuine reason is there because of which the applicant could not file the appeal in time, so in that case, the first appellate authority may admit the appeal even after the expiration of 30 days from the date of receipt of decision by the applicant or the expiry of prescribed period. Then subsection 2. Subsection 2 says that when the appeal under section 11, that is third party information, if the third party is appealing, where the appeal under section 11 against the decision of the PIO to disclose third party information is made, then appeal by the third party must be made within 30 days from the date of order. So this is in case of third party information. So applicant is filing RTA application before the PIO and the information relates to third party. PIO within 5 days will write a letter to third party that please give a representation within a 10-day period regarding whether you consent to the disclosure of information or you do not consent to the disclosure of information. So within 10 days, the third party will make a representation. Now suppose the third party says, please don't disclose the information. But the PIO decides to disclose the information because the PIO thinks that the public interest outweighs the harm to protected interest. Now the third party can appeal against this decision of PIO within a period of 30 days from the date of passage of the order by PIO giving the decision. So within a period of 30 days of the decision of the PIO regarding disclosure of the information, the order passed by PIO, within 30 days the third party can appeal before the first appellate authority. Then subclause 6 of the section 19, it says that appeal under subsection 1 and 2 shall be disposed of within 30 days. So first appellate authority will dispose of the appeal within a period of 30 days of the receipt of appeal or within such extended period not exceeding 45 days. So within such extended period not exceeding 45 days from the date of filing the appeal for reasons to be recorded in writing. So maximum will be 45 days. If there are sufficient reasons which are recorded in writing, then the appeal can be disposed of within an extended period of 45 days also. Normally appeal will be disposed of by first appellate authority within 30 days, but if there are sufficient reasons which are recorded in writing by the first appellate authority, then appeal can be disposed of within an extended period of 45 days also. Then with subclause 3 of the RTA Act says that second appeal is to be filed within 90 days from the date on which the decision should have been made or was actually received. From the date on which the decision should have been made by the first appellate authority or was received by the applicant. So the second appeal can be made within a period of 90 days. From the date on which the first appellate authority should have made a decision, suppose the first appellate authority did not make any decision, but it should have made a decision within a 30-day period. So from that date, within a period of 90 days, the applicant can file second appeal before the Information Commission. Or suppose the first appellate authority gives a decision, and suppose the decision is not in favor of the applicant. So applicant can appeal against this decision. The first appellate authority will give the notice of its decision to the applicant also. So when the applicant receives the notice, applicant will receive the notice. From that date, within a period of 90 days, applicant can apply to the second appellate authority. And the information commissions at the central and state level, whether it is a central information commission or it is a state information commission, they can receive the appeal after 90 days also if the applicant was prevented by sufficient cause from filing the appeal. Then subsection 4 of this section 19, it says, if the decision of the PIO against which appeal is preferred, it relates to third party. So suppose the PIO decides to disclose the information, the third party information, against the decision given by third party, against the representation made by third party. The third party said that don't disclose the information, but the PIO decides to disclose the information because the PIO thinks that public interest is outweighing the harm to protected interest. So third party appeals before the first appellate authority. So now it says, if the decision of the PIO against which the appeal is preferred relates to third party, then now third party appeals before the first appellate authority, and first appellate authority also gives a decision that is against the interests of third party. So third party can appeal to the second appellate authority, and the second appellate authority will also give reasonable opportunity of being heard to the third party. So third party needs to be given reasonable opportunity to be heard by the appellate authority. Now the next point is subsection 5 of the section 19. In appeal proceedings, the onus to prove that the denial of request was justified shall be on the PIO. So the responsibility to prove that the denial of request to the applicant, it was justified, it shall be on the PIO. So the responsibility is not on the applicant. The applicant does not need to prove that the RTA application filed by the applicant was genuine, or the applicant had the right reasons to file the application. The applicant does not need to prove all this. Now, if the PIO has denied the request for information, if the PIO has denied the request for information, in that case the burden of proof will be on the PIO. The PIO has to prove that the denial of request for information was justified. In subsection 7 of the section 19, it deals with decision. It says that the decision of the state or the Central Information Commission or the State Information Commission, it is going to be binding. It will be binding, and no appeal can be made before any court of law against this decision. In subsection 8 of the section 19 of the Act, it talks about what the Central Information Commission or the State Information Commission, what it can direct the public authority to do. So what directions can the Central Information Commission or the State Information Commission give to the public authority? It is dealt with under section 19 of the RTI Act. Section 19 subclause 8. So what it can direct? What can the Information Commission direct the public authority to do? We will just cover all these provisions in brief. So in its decision, the Central Information Commission or State Information Commission has the power to require the public authority to take any such steps as may be necessary to secure compliance with the provisions of the RTI Act. So what can it do? It can ask the public authority to provide access to information, in the prescribed form. Then it can ask the public authority to appoint a public information officer. It can ask the public authority to appoint PIO, provide access to information in prescribed form. It can ask the public authority, that is the government organization, it can ask the government organization to publish certain information, certain information or categories of information, and it can ask the public in the organization to submit an annual report. Under section 4(1) subclause B. Now we have already studied about section 4(1) subclause B. It says that within 120 days of the enactment of RTI Act, every organization needs to publish the particulars of its functioning, the particulars of duties of various employees and officers, the remuneration received by employees, compensation received by employees, the beneficiaries of various schemes, the facts on the basis of which the policies of the organization are framed, the budget allocation, the disbursements, the expenditures made by the organization, and what is the procedure for getting information from that organization. All these need to be disclosed under section 4(1)(b). So the Information Commission, it can tell the public authority to give an annual report under section 4(1)(b) regarding whether it has complied with the provisions of section 4(1)(b) or not. Then it can also direct the public authority to give training to its employees regarding the RTI Act. And it can tell the public authority to make changes to its practices in relation to maintenance of records, maintenance, management and destruction of records. So changes to its practices with regard to maintenance, destruction, management of records. So this is what the Information Commission can direct the public authority to do. Also a very important provision is that the Information Commission, it can impose penalties. It can impose penalties on the PIO, and penalties can be penalties for not receiving the application or for giving incorrect information, for not giving the information in time. Penalty can be ₹250 per day till the information is given or till the application is received, subject to a maximum of ₹25,000. Now we move on to the next important section, that is section 20. Section 20 deals with the penalties under the RTI Act. So penalties under the RTI Act are dealt with in section 20 of the Act. If the Information Commission is of the opinion that PIO has refused to receive the application for information without reasonable cause, so refused to receive the application for information or not furnished the information within time, not given the information within the prescribed time period, or has denied the request for information with a malified intent. So with a malified intent has denied request for information, or has knowingly given incorrect information or incomplete information or misleading information, or has destroyed the information or obstructed in any manner the furnishing of information. So in that case, penalty can be imposed. Penalty will be ₹250 per day till the application is received or the information is furnished, and total amount not to exceed ₹25,000. And the PIO is to be given a reasonable opportunity to be heard before the penalty is imposed. So PIO will be given reasonable opportunity to be heard before the penalty is imposed. And the burden of proof to prove that the denial of request for information was justified will be on the PIO. Then the Information Commission can also recommend disciplinary action against the PIO under the service rules that are applicable to the PIO. Now we move on to what are the organizations that are exempted under RTI Act. So section 24 of RTI Act deals with the provisions regarding the organizations exempted from RTI Act. And second schedule of the RTI Act, it covers the names of the organizations exempted from RTI Act. There are a total of 23 organizations that are exempted under RTI Act. Now we will try to memorize the names of these organizations, important organizations, using again the chunking method, that is clubbing the similar organizations together. The first group we see is all these organizations, they are related to security in some way, internal security or security in general. See, Assam Rifles, Border Security Force, that is stationed at the border between India and Pakistan. The Seema Suraksha Bal, stationed at the border between Nepal and Bhutan. The Special Protection Group, the DRDO, that is the Defense Research and Development Organization, the Border Roads Development Organization, the National Security Organization Secretariat, that is the NSO Secretariat, National Security Organization Secretariat, then Indo-Tibetan Border Police at the India-China border, the Special Frontier Force at the line of actual control between India and China, the CRPF, that is the Central Reserve Police Force, the CISF, Central Industrial Security Force, the National Security Guard, the Special Branch of CID in Andaman Nicobar Islands, the Crime Branch of CID in Dadar Nagar Haveli, the Lakshadweep Police Special Branch. So these are organizations that are related to security in some way. In this way we can memorize them. Then we come to the next group that are clubbed together. This is clubbing of these organizations only for the purpose of memorization. Actually, there is no such clubbing in the act itself. So these four organizations we can see they are related to finance. The Financial Intelligence Unit of India, the Directorate of Revenue Intelligence which is under control of Finance Ministry, the Central Economic Intelligence Unit which is again under the control of Finance Ministry, the Directorate General of Income Tax. So these four, they are related to finance in some way. Then these two organizations we see, Intelligence Bureau and the Narcotics Control Bureau. So Intelligence Bureau is related to intelligence we know, and Narcotics Bureau if it is related to drug trafficking. It prevents it stopping the crimes like drug trafficking and catching the offenders. So we can say that it is related to intelligence related to drugs. So in this way we can memorize these two organizations. So IB and National Narcotics Control Bureau. So Narcotics Control Bureau, the function is to combat drug trafficking, to catch the offenders who are related to drug trafficking. Then we move on to the next group, that is the Aviation Research Center and the National Technical Research Organization. As we can see, both these organizations are related to research. In this way we can memorize them. So these were the organizations that are exempted from the RTI Act. Then we come to the issue of including political parties under the ambit of RTI Act. Now the Central Information Commission in its order on 3rd June 2013, it said that the 6 national political parties, they should be included as public authorities under RTI Act. So the 6 national parties should be included as public authorities under RTI Act, and they should disclose their details. They should appoint public information officers, and they should appoint the appellate authorities also. The first appellate authority. Then in 2015, the first and second appellate authority. We know that the second appellate authority is always the information commissioners. So the first appellate authority is the senior official within the organization. Then in 2015, there was the Subhash Chandra Agarwal case. Subhash Chandra Agarwal, he filed a PIL. He filed a PIL in the Supreme Court. And the Supreme Court then issued, Subhash Chandra Agarwal filed a PIL seeking to bring political parties under RTI Act, seeking disclosure of information by political parties. So Supreme Court, it issued a notice. In response to this PIL, Supreme Court issued notices to the 6 national parties regarding why they should not be brought under the RTI Act. And Supreme Court also sought responses from the Centre and from the Election Commission. Now Subhash Chandra Agarwal had moved the PIL in Supreme Court seeking declaration that political parties are public authorities. Political parties are public authorities and they should disclose details of income and expenditure for public scrutiny so that transparency and accountability in the functioning of these recognized national and regional political parties that can be ensured. So he had filed a petition seeking a declaration that the political parties, they are public authorities. They are public authorities under the RTI Act. And then in response, Supreme Court issued notices to the 6 national parties asking why they should not be brought under RTI Act. And Supreme Court also sought responses from the Centre and Election Commission in this regard. Now next we come to the arguments against bringing political parties under RTI Act and the arguments for bringing political parties under RTI Act. First, what are the arguments against? One is that the provisions of Representation of Peoples Act 1951 and the IT Act, they are already applying to political parties and they have brought the necessary transparency in the working of political parties. Also, information relating to political parties has already been disclosed by the Election Commission on its website. So, information relating to political parties has already been disclosed by the Election Commission on its website, and there are already provisions of the Representation of Peoples Act and IT Act. They are already applying to political parties. So, why apply additionally the provisions of RTI Act to political parties? This is the first argument against bringing political parties under the RTI Act. And these arguments were presented by the government before the court. Then, bringing political parties under RTI Act, it is going to adversely affect their internal functioning, because people may ask why political parties have selected a certain candidate, on what basis a candidate was selected for contesting elections. So this is going to disturb the internal functioning of political parties. Also, political parties are not established by any constitution, by the constitution or any law. So they should not be treated as public authorities. Also, Central Information Commission, it has made a very liberal interpretation of Section 2 subclause H of RTI Act. Section 2H deals with public authority. So Central Information Commission has made a very liberal interpretation of Section 2 subclause H of RTI Act, which deals with definition of public authority. And this led to an erroneous conclusion that political parties are public authorities. Now these were the arguments against bringing political parties under RTI Act. Now we move to the arguments for bringing political parties under RTI Act. Political parties are receiving subsidies, tax exemptions, etc. from the government. So since they are receiving benefits from government, they should be brought under RTI Act. Political parties are also receiving free airtime on the state-owned TV or radio and Doordarshan. So they are receiving free airtime. Recognized national and state political parties are receiving free airtime on the state-owned TV, radio and Doordarshan. So since they are receiving benefits from the state, they should be brought under RTI Act. They are also the recognized national and state parties. They are also provided residential facilities for residential and official use by the Directorate of States. So they are receiving benefits from the state should be brought under RTI Act. Also, when the political parties they come to power, they win elections and they come to power, then they start controlling the tax money. And hence, since they are controlling the tax money, which is people's money, they should be made accountable to the people. Also, we just studied in the points against bringing political parties under RTI Act that Income Tax Act is already applying to political parties and it has brought the necessary transparency. But actually, under the Income Tax Act, it is not mandatory to disclose information on donations less than 20,000. So on donations less than 20,000 rupees, it is not mandatory to disclose information under the Income Tax Act. So since these donations are not covered under the Income Tax Act, they should be covered under RTI. So political parties, they should be brought under RTI Act because Income Tax Act does not cover the donations less than 20,000. Donations to political parties which are less than 20,000 rupees. Now we come to the next slide. We have just covered the arguments for and against bringing political parties under RTI Act. Now we come to the next slide. The next slide says that in 2018, a BJP member, Ashwani Kumar Upadhyay, he filed a PIL in court asking for bringing political parties that are recognized under Section 29A of Representation of People's Act to be brought under RTI Act. So Ashwani Kumar Upadhyay filed the PIL in court saying that political parties covered under Section 29A of the Representation of People's Act and they should be brought under the RTI Act. Now political parties, they did not comply with the CIC order. The Central Information Commission had issued an order on 3rd of June 2013 asking political parties to disclose details and to appoint PIOs, but the political parties did not comply with this order. Also, the central government has not appointed the adequate number of information commissioners in the Central Information Commission. Also, state government have also not appointed the required number of information commissioners in their respective state information commissions. Now, the RTI Amendment Act was carried out in 2019, the amendment to the RTI Act, and it tried to weaken the RTI Act by changing the tenure of information commissioner and of the chief information commissioner and the other information commissioners. See, earlier the tenure was 5 years or 65 years of age, whichever is less. But after the amendments to RTI Act, now the new tenure is to be determined by central government. It is as determined by central government. So central government is controlling the tenure and service conditions of the information commissioners. So now this is the case. Now central government is controlling the tenure and service conditions of the information commissioners. So in this way, by controlling the tenure and service conditions, central government is indirectly controlling the functioning of the RTI Act, functioning of the information commissions. This is going to adversely affect the impartiality of these information commissions. So in the RTI Amendment Act of 2019, it diluted the RTI Act by changing the tenure of information commissioners, and now the tenure will be as determined by the government. Tenure of both the information commissioners at the central level and as well as the state level. That is, the chief information commissioner and the other information commissioners at both the central level and the state level. Now they will be as determined by the central government. Their salary and terms of service will be as determined by central government. So this will adversely affect the impartiality of these information commissions. So these were about the amendments that were carried out to the RTI Act in 2019, which diluted the RTI Act in a way. And now after the amendments, the information commissioners, the Chief Information Commissioner as well as other information commissioners at the central and state level, they are not eligible for reappointment. Now, having covered the RTI Act, the issue of political party, bringing political parties under RTI Act, we are going to have a brief overview of the RTI Act in the state of Rajasthan. Now in Rajasthan, on 6th of April 2006, Aruna Roy, who is an ex-IS officer, she started the movement for right to information. Aruna Roy is the leader of the Mazdoor Kisan Shakti Sangathan, an NGO. So Aruna Roy is the leader of this organization, the Mazdoor Kisan Shakti Sangathan, and Aruna Roy, she started the campaign for right to information in Rajasthan from Byawar, from a place called Chand Gate in Byawar in Ajmer district on 6th of April 2006. Now in Rajasthan, the Right to Information Act, it was enacted for the first time for panchayats on 30th of December 1996. So on 30th of December 1996, the RTI Act, the Right to Information, was enacted for the panchayats in Rajasthan. Then on 26th of January 2000, on 26th of January in the year 2000, the RTI law was made implementable, was made applicable in Rajasthan. So right to information was implemented in the whole state of Rajasthan, in the state of Rajasthan on 26th January 2000. So this was before the enactment of the Central RTI Act. So this was before the enactment of the RTI Act of the Centre. On 26th of January 2000, the RTI, the Right to Information, was implemented in Rajasthan. Now, after the Central Act was implemented, the Central Act was implemented on 12th of October 2005. After this, the state of Rajasthan established its State Information Commission. So, state of Rajasthan established its State Information Commission on 18th April 2006. This is after the enactment of the Central Act in accordance with the provisions of the RTI Act 2005. So, this was a brief overview of the RTI Act in the state of Rajasthan. Now, in this slide, in this video, we have covered about the definition of right to information, about the different provisions of the RTI Act, about the issue of bringing political parties under the Right to Information Act, and also about the right to information applicability in Rajasthan. So with this, we come to the end of this video. Thank you.